All right, welcome to the Explainer. Today, we're going to pull back the curtain on something that's complex and, frankly, pretty intimidating: the child custody trial. We're going to break down a lawyer's entire playbook, from their first move all the way to the final buzzer. So, where do we even begin? Well, let's just dive right in. The famous trial lawyer Louis Nizer really hit the nail on the head here. This one idea, it's the absolute key to understanding a custody trial. See, it's not like a criminal case where you're focused on a single thing that happened in the past. It's all about persuading a judge to believe in a certain future for a child. And that's exactly what makes these trials so unique, right? The whole goal is to give a judge enough information to make what's called a reasoned prediction. I mean, think about it. It's basically an educated guess about what is going to be in a child's best interest from this day forward. So, right from the get-go, a lawyer is at a fork in the road. They have to pick a core strategy. They can go on the attack, the destructive approach, and just try to tear down the other parent. Or they can take the constructive approach, building up their own client's strengths. And honestly, as a general rule, judges are way more receptive to that positive angle. And this brings us to a point you've really got to understand. The real battle, it isn't won in the courtroom. No way. The most crucial work happens way before anyone ever sees a judge. It's all about painstaking preparation, deep dive research, and just plain smart strategy. So what's the secret sauce to all this prep? Well, here's the #1 rule in family law, and it's a big one. Know your judge. I'm serious. A good lawyer is going to dig into everything: the judge's career path, their professional background, maybe even their personal history. Why? Because all of that stuff shapes how they see the world. For instance, a judge who used to be a prosecutor is probably going to look at a drug allegation a lot differently than a judge who is a social worker, right? Nailing those nuances is absolutely critical. Okay, so you might be thinking, after all that work, why on earth would lawyers make one last big push to settle right on the courthouse steps? Well, it's pretty simple. Trials are brutal. They cost a fortune. They're an emotional roller coaster, and at the end of the day, you're rolling the dice by leaving a decision this big in someone else's hands. A huge part of this prep is getting the client ready for their big moment. This is vital. A lawyer will go over everything: what to wear, the case theme, the role-play testimony over and over. And believe me, this is not just for show. When a case is a real toss-up, how that client comes across on the witness stand, their demeanor, their honesty, that can literally be the single deciding factor. It's that important. Okay, so the prep work is done. Let's head inside the courtroom. This is where all that planning gets put to the test. And it starts with the very first words the judge hears. You see, the opening statement is so much more than a summary of facts. It's where the lawyer plants a flag. It's where they establish a memorable theme. Think of it like a theme song for a movie. It gives the judge a simple, powerful idea to hang on to, a lens to see all the upcoming evidence through. So what do these themes actually look like? Well, a classic one is stability versus instability. The lawyer frames their client as the stable rock, while the other parent, well, not so much. The whole point is to create this one clear, persuasive story that keeps the judge focused and, of course, always points back to what's best for the kid. And it's not just what you say, it's when you say it. Deciding who testifies when, that is a massive strategic move. The playbook is simple. You want to make a big splash right at the start and leave the judge with something powerful at the very end. You start strong and you finish even stronger. All right, let's get into the real meat of the trial now, the presentation of evidence. This is where the lawyer basically becomes a master storyteller, building their case for the judge one piece at a time. The direct examination, this is the absolute heart and soul of the trial. This is where the lawyer tells their story through their own client and their own witnesses. The goal? To lay out the facts so clearly and logically that by the end, the judge feels like there's really only one possible conclusion they can come to. And this is a perfect example of how it's done. It's actually brilliant. A lawyer isn't going to just ask, "So, are you a good parent?" Instead, they paint a picture with all these small, detailed questions about daily life. Who fixes the school lunches? Do you help with homework? Do you read bedtime stories? Each answer is like a new brushstroke until you've got this complete, compelling portrait of a parent who is deeply involved. Now, to paint that picture, a lawyer uses 4 main types of evidence. You can think of it like a toolkit, where each tool has a very specific job to do in building the case. So let's peek inside that toolkit. You've got testimonial evidence. That's just what people say on the stand. Then there's real evidence, an actual physical object. You've also got demonstrative evidence, like a chart or a graph to help explain things. And finally, documentary evidence. Paperwork like school reports or medical records. A good lawyer uses all of these together to create a multi-layered, really persuasive case. But in today's world, there's a huge new player in the evidence game. We're talking about electronically stored information, or ESI. And yep, that means emails, texts, social media posts, the whole digital shebang. And check this out. This is from a real case, a single text message. But look at what it says. It gave the judge this raw, unfiltered glimpse into the true nature of the parents' relationship. And you can bet that kind of powerful, undeniable evidence had a huge impact on the final decision. All right, so now we're getting to the end game. Let's talk about the final stages of the trial, where everything gets sharpened up and the lawyers make their last pitch to the judge. First up is cross-examination. This is the chance to poke holes in the other side's story. But here's something you have to get. It's not like in the movies. It's not about some dramatic gotcha moment. A good cross-examination is more like surgery. It's a precise, carefully planned attack on the facts of your opponent's case. And to do that, lawyers often follow some really strict rules, like these famous ones from the trial attorney Irving Younger. The goal is total control. You use short, leading questions to box the witness in. You never, ever ask a question you don't already know the answer to, and you never give them a chance to explain themselves. And then you have the closing argument. And again, forget what you've seen on TV. It's not some long, emotional speech. It's meant to be brief, clear, and direct. The whole job is just to remind the judge of the most important pieces of evidence and then tie it all back one last time to that original case theme. And just when you think it's all over, it might not be. A lawyer can actually file what's called a post-trial motion. They can ask the judge to reconsider the decision or even grant a total do-over, a new trial. But, and this is a big but, they have to have a really good reason, like proving a major legal mistake was made or that some game-changing new evidence has popped up. Which brings us right back full circle to this central puzzle of a custody trial, doesn't it? It's this fascinating place where the art of storytelling meets the cold, hard weight of evidence, and they combine, not to judge the past, but to literally shape a child's entire future.